friends, I Advocate Shailesh Joshi. Welcome to all of you on this YouTube channel. Today in this new video, I am going to share some legal information about mutual consent divorce. So let's understand what is mutual consent divorce, the provisions of law in regard with the same. So friends, after marriage, when husband and wife do not want to continue their marital relationship and they want to terminate their matrimonial knot peacefully, they may file mutual consent divorce petition. Now, mutual consent is possible when both the parties, that is, husband and wife, do not have any kind of allegations against each other and they have mutually agreed to file the petition and have resolved all their marital issues amicably. Marital issues means the issue of maintenance, the issue of alimony, child custody, visitation rights of children, joint property issue, then marriage gifts, exchange of marriage gifts and articles, and stridhan. Now the next question is that where the petition for mutual consent may be presented. So subject to the provisions of the Act, the petition for dissolution of marriage by mutual consent may be presented to the family court or district court. Now the next question is, under the provisions of which law petition for mutual consent may be filed? So friends, it is very important point. This is very important point to understand. If the parties are Hindu by religion and if their marriage is solemnized as per the rites and rituals of Hindu religion, then the petition of divorce of such parties should get filed under section 13 subsection B of Hindu Marriage Act 1955. Likewise, if the parties are Christian by law and if the marriage between the parties is solemnized under the rites and rituals of Christianity, the divorce petition of such parties should get filed under section 10A of Divorce Act 1869. Likewise, if the parties are Parsi by religion and their marriage is solemnized as per the rites and rituals of Parsi religion, then the petition for a dissolution of marriage by mutual consent of such parties should get filed under section 32B of Parsi Marriage and Divorce Act 1936. Now, irrespective of religion, it means even though the parties are Hindu by religion, Muslim by religion, Christian by religion, Parsi by religion, or of any other religion, but if the marriage between the parties is solemnized as per the rules and regulations laid down in Special Marriage Act, then the divorce petition of such parties should get filed under section 28 of Special Marriage Act 1954. Now friends, the third question, it is also very important to understand what are the mandatory conditions of law to file mutual consent divorce petition. So let's understand here. There are two mandatory conditions of law to file mutual consent divorce petition. The first is that there should be a completion of 1 year period to the matrimony from the date of marriage before the presentation of the petition. And the second condition is that both the parties should have been living separately for more than 1 year or more than that. But here, let's understand again, if the parties are Hindu by religion and if their marriage is solemnized under the Hindu Marriage Act, if the parties are Parsi by religion and if their marriage is solemnized under Parsi Marriage and Divorce Act, and if the marriage between the parties is solemnized under the rules and regulations laid down in Special Marriage Act, in such case only the separation of 1 year or more than that is required. It means if the parties are Christian by religion and if their marriage is solemnized under the rites and rituals of Christianity, and if they want to file the petition under Indian Divorce Act 1869 for mutual consent under section 10A, in that regard, the separation between the parties should be more than 2 years or more than that. Now friends, let us understand the next question, that is when the Honorable Court may pass decree of dissolution of marriage. In mutual consent divorce petition, on the motion of the parties made not earlier than 6 months from the date of presentation of the petition and not later than 18 months, and if from the said date the petition is not withdrawn, and if the court, on being satisfied after hearing both the parties and making inquiry as the court may think fit, that the marriage between the parties is solemnized and the averments in the petition are true, court will pass the decree of the dissolution of marriage. It means, in short, in mutual consent divorce, the decree of dissolution of marriage may be passed after 6 months but before 18 months from the date of presentation of the petition. So now friends, the next question is that whether the cooling off period of 6 months may be waived. The answer of this question is yes. The cooling off period of 6 months may be waived, but it is the discretionary power of the Honorable Court. If the court satisfied that the cohabitation between the parties is not possible, in that case, the Honorable Court may waive off the cooling off period of 6 months. In this regard, there is a very remarkable judgment of the Apex Court of India in the matter of Amardeep Singh versus Harvind Kaur. Now the next question is whether the consent for divorce can be withdrawn. Again, the answer of this question is yes. The parties at the petition may withdraw their consent before the decree of dissolution of marriage at any time. And if the consent of any of the party is withdrawn, the court may not pass the decree for dissolution of marriage. Now the next question is whether the parties may file the petition for mutual consent divorce by power of attorneys. Again, the answer of this question is yes. Parties may file the petition for mutual consent divorce by their power of attorneys. In any due to any technical reason, if it is not possible for the parties to give their physical appearance before the court, then they may be permitted to be represented by their power of attorneys. In this regard, there is a very remarkable judgment of the Honorable Bombay High Court in the matter of Harshada Deshmukh versus Bharat Deshmukh. And there is one another judgment of the Honorable Bombay High Court in the matter of Mukesh Shinde versus Palak Shinde. In this matter, the Honorable Bombay High Court has stated that in the light of technological development, e-verification and e-counseling by video conferencing is also permitted. So now friends, the next question is, what are the documents required to file a mutual consent divorce? So let's understand here, there are certain documents required to file petition for mutual consent. The first is marriage photo of the parties, original wedding card, original marriage certificate, then 3 passport size photograph of each party, separate address proof of both the parties, photo IDs of the parties, and if the parties have child, they may produce the birth certificate of their child. So friends, in this video, I have explained the basic details in regard with mutual consent divorce. If you like this information explained you in this video, you may like it, share it and subscribe it. Thank you very much friends.